Welcome to Case by Case. This is a podcast brought to you by Calum and Luke Zadkovich. It's great to have you on board, everyone, today. Thanks for listening in. Hello, Calum. How are you?
Hey, Luke. I'm good. Thank you. I'm good. I'm looking forward to this one, actually. We've got Lord Justice Mayles again, and we're fans. So there's a very interesting judgment here to discuss.
Roll out the Lord Justice Mayles fan club again, and he's on the winning side of this split decision. Lord Justice Arnold and Lord Justice Newey also gave judgments with, it was Arnold, wasn't it, who was dissenting?
I think it was Arnold dissenting. Yeah, it was Arnold dissenting.
Yeah, Arnold dissenting, LJ. And I think it's a fascinating decision. I know I say that a lot. I know it's pretty much how I open every one of these things. But this one it really is, because it throws to not only force majeure, and we love force majeure clauses here on this podcast, but it has a sanctions angle. And Calum and I, we've been involved in all sorts of sanctions-related matters over the years, and particularly this year with what's so devastatingly played out in and around Russia. So what do you think, Calum?
I thought long and hard about this, actually, after reading the judgment. Because if any time you have Court of Appeal split judgment, it's not obvious what the correct answer is, and there probably is no truly correct answer. I think that this is the right decision, but I think in the future people are going to really jump on this case as one that they want to rely on, and it's going to be one of those cases that just gets trotted out in so many letters exchanged between lawyers to try and ask for something more than they actually are really allowed to under law. And we'll get into why that is. But I think this is going to be, I think it's the right answer, but I think very quickly this judgment will be confined to its own facts.
Interesting. I agree. I think we're speaking with a lot of trepidation, which is unusual for us. Usually, we'll come out and say, I agree or I don't agree. I think I agree with the ultimate decision here, but with some reluctance, I've got to say. And I flip-flopped throughout reading this at least 2 or 3 times. And I by the end of it, I think I got to where Lord Justice Mayles, who gave the leading decision, got to. And I can kind of see why that he's gone that way, in the context of we have to look at the force majeure clause, the wording of the force majeure clause, and construe this clause rather than straying into looking at general principle around whether a party can be obliged to accept, in a force majeure context, a non-contractual performance. And I bristled with that concept. But when you think about this as you're looking at a force majeure clause, you're looking at what the clause provides for. You've got to work within the parameters of what's been written in that force majeure clause. Then suddenly you can kind of see, well, okay, it may be more of a practical kind of analysis, more of what are reasonable endeavors in this case. I know it didn't turn on what is the definition of reasonable endeavors, but I think when you conceptualize this decision as working within a force majeure clause, it's easier to accept the decision. But when you extrapolate it out, and there's the hypothetical that Lord Justice Arnold put in there as well, and you start to think about other situations, it's like, well, yeah, I could have a bit of fun with this decision, I think, in other cases. And that's what you're saying, right?
Yeah. Exactly. I'm saying that there are so many other situations where people will try and use this judgment to say, oh no, but you could do this, you could do that, and you have to, and that's not what the judgment says. I think that's the point for me, is that the judgment is quite measured and narrow in what it says the party is required to do to overcome the FM event. But just the mere fact, we're straying into giving away the game here, but just the mere fact that there was a requirement to do some kind of slightly non-contractual performance to overcome the force majeure event is going to open the door to this being argued countless times in correspondence around FM, I think.
I think you're right. And the ultimate question, let's come back to it, is does it open the door on appeal further up? Does this go to the Supreme Court? Let's park that question. Let me actually introduce the case. This is a Court of Appeal decision from England and Wales. The neutral citation number is 2022 EWCA Civ 1406. The decision was handed down yesterday, hot off the press, handed down on the 27th of October 2022. We've given the names of the justices that are involved. The appellant and defendant is a company called RTI Ltd. They're related to the Roussel Group, or affiliated to the Roussel Group, Russian entity, or Russian, owned anyway. And the respondent on the appeal and claimant are the owners, MUR Shipping BV, a Dutch entity, I think that, from Dutch, and actually RTI is from Jersey. We've gone through two levels here. Initially, there was a decision of the arbitrators, LMAA arbitrators, and then that decision was appealed under Section 69 of the Arbitration Act 1996 to the English High Court. The High Court upheld the appeal, reversing the decision of the arbitrators, and we'll get into what those decisions were about in a moment. And then the High Court's decision was appealed to the Court of Appeal, and ultimately the appeal was dismissed. We then have a split decision, as we said, Lord Justice Males giving the lead decision, with Lord Justice Newey agreeing, and Arnold LJ giving the dissenting decision. So, with that all said, Calum, should we start with a snapshot of the facts here?
Yeah, I think the facts and the question, because the question was so narrow that the court had to answer, and basically the question is, can a ship owner under a COA rely on a force majeure clause as suspending an obligation to load cargo in circumstances where the ship owner, I suspect, I don't know exactly how this will be formulated, but in circumstances where the ship owner reasonably, and I think because of the facts found in the arbitration, correctly considers that the payments will not be forthcoming from the charterer due to a sanctions issue. And what had happened to give rise to that question is that you had the COA between MUR Shipping, the Dutch company, who are the owner, and RTI, who are the charterer. RTI were related to a Russian entity that was subject to a sanctions regime. So the Russian entity that was subject to the sanctions regime, but not RTI. As you well know, Luke, and as many people involved in, I guess, international trade and commodities know, if you are close to touching on sanctions, then banks will necessarily get very jumpy, and correctly get very jumpy, and they will do things like freezing money when it's in being wired through accounts. It can be very hard to clear, in particular US dollar funds, where one of the parties involved in that payment on either side is related to a sanctioned entity. And this was the concern here, was that MUR said, to the charterer, you're not going to be able to pay us freight. We will load our cargo and you will not be able to pay us freight because the money's going to get stuck somewhere. And RTI said, okay, but that we're only subject, well, we're not subject to any sanctions regime, but the only sanctions regime that comes close to applying are US sanctions. And actually, we don't need to involve US intermediary clearing banks because we can pay you in euros and the money will be converted by your bank into dollars. And we will bear all of the attendant costs on paying in euros rather than dollars, everything else. So you will end up with the correct US dollar amount in your account, but the payment will leave our account in euros rather than in dollars. And the ship owner said, no, we consider this an FM event. Your non-payment is or the likelihood of you not being able to pay is FM. We're not going to load. We're not going to accept any cargo. Sorry. And that gave rise to this dispute.
Yeah, and it's a really interesting fact pattern because we have seen many cases in and around these types of issues repeatedly, and having to contend with whether it's charter party language or contractual language. Here we had a COA that provides for certain events, whether it's a force majeure event or if it's a sanctions clause, right, where the contractual clause may provide for certain things to happen, and you're having to assess whether sanctions apply or not. And there was an open question in the underlying arbitration here as to whether US sanctions did actually apply to RTI. Ultimately, the arbitrators found that it didn't. And that wasn't subject of the appeal or anything. But those decisions are not, those kind of calls are not easy to make at times. And at our firm we advise on both English law on the underlying contract, but also in this case US sanctions. It could have been UK sanctions or EU sanctions, and so we're often providing the advice on both sides. It's we're doing the contractual work as well as the sanctions advice, and it's really fascinating to see it play out in this way and contending with what the banks may or may not do, how that then impacts on the contract. There's a lot in it, and it's not easy. Now, trying to give that some kind of some guardrails on the analysis, and as we opened up, you have to come back to the question of what does the force majeure clause say, and we are dealing with, and for those that haven't come across force majeure clauses all that much, so it's important to put some kind of guardrails around the discussion. And give us a focal point here. And when we're dealing with force majeure cases under English law, what is important is what is in the force majeure clause. There's no general principle at law relating to force majeure. There's frustration, which is something different, but it's important to ground the discussion and the analysis in the words of the clause. And that's what the court does, right? When the court goes and looks at this and analyzes this clause, it starts with some really interesting points, right? And from a practitioner's perspective, seeing how the court approaches the analysis, I think, is always instructive as to how we should do it. So it starts with, what does the word "it" mean in the clause, right? And when it says that. So I won't read the whole clause out because I think it'll just take too long. If you're really interested in the case, go to the clause and read it. But there are some key points in it. Looking at clause 36.3, a force majeure event is an event or state of affairs, right? Inverted commas, event or state of affairs, which meets all of the following criteria. So that event or state of affairs is then the "it" that is being referred to in the next few subclauses. A, it is outside the immediate control of the party giving the force majeure notice. B, it prevents or delays the loading of the cargo at the loading port and or the discharge of the cargo at the discharging port. C, it is caused by one or more of acts of, and it's your usual list of act of God, extreme weather conditions, etc., through to restrictions on money transfers and exchanges. So that's subclause C. And then the all-important one for this case is subclause D. It cannot be overcome by reasonable endeavours from the party affected. And we're going to explore what that means in a moment. Subclauses A, B, and C were all findings that were made by the arbitrator, and the Court of Appeal took some time, actually. I don't know if you picked this up, but took some time, Calum, to explain that the scope of the appeal is quite narrow and limited to only looking at subclause D, and went so far as to say there's a question as to whether there were arguments around whether this was even a force majeure event in the first place. It didn't go into that, but there was this kind of nuanced comment in there. Did you pick that up?
I picked up a few references in this judgment to, firstly, exactly as you say, it's very clear about the scope of the scope that the court has in issuing this judgment, and it's instructive. I think most practitioners will be more than aware of this. But firstly, when you're appealing an arbitration award, you cannot appeal a factual finding by the tribunal, subject to some very limited exceptions. The facts that the tribunal finds are the facts, so you can only appeal where they get the law wrong. But separately to that, you can also only appeal on law if you have permission. So the arbitrator's award is final in terms of all the facts that they find, but also in terms of all of their legal findings on which a party did not get permission to appeal. And that's then true kind of for the second tier. When you get to the Court of Appeal stage, only the legal questions that are appealed out of the commercial court, normally the commercial court, can be decided by the Court of Appeal. So you then have the situation where the Court of Appeal are all sat there, and you can tell they're slightly thinking, well, hang on a minute. It's not certain that this force majeure event satisfies paragraphs A, B, or C. But we're taken to, we're compelled to find that it does, or that we don't even have the chance to find otherwise. Our judgment is simply looking at a legal question. It's not looking at whether or not, as a matter of fact, paragraphs A, B, and C are satisfied in this clause. And you can tell from a lot of the judgment that they weren't entirely on all fours with that factual decision or that factual finding. And one of the things which I think is very clear from this, kind of reading behind the lines, reading between the lines even, is that there was a lot more going on in the initial case in the arbitration. And I think it was one of those situations where the arbitrators were probably dealing with a vast number of facts to find. It was probably not practicable for them to detail the reasons for their factual findings on every single fact. And on this one, I would imagine, or it certainly seems as though, and there's a comment made by Lord Justice Males to this effect, that the analysis on this specific question, and in particular on the facts that underpin this part of the decision in the initial award, there wasn't kind of chapter and verse given by the tribunal. And it's also mentioned a number of times that there were so many other points for the tribunal to consider. So it's kind of an interesting aside, I guess, is that suddenly there's this probably a small part of a much larger decision, which then ends up in the Court of Appeal, and it's an interesting interaction between the world of arbitration and the appeals process through which you then have this slightly unsatisfactory, I suppose, if you're Lord Justice Males, finding that he's not in a position to actually challenge any of the arbitrators' findings on these initial paragraphs. I mean, the key one, of course, or I think there are two maybe that where it's seriously questionable whether or not the force majeure event meets the right criteria, firstly is whether it prevented the loading of the cargo. And the force majeure event we're talking about here is money not being transferred. So it's not entirely clear to me as a matter of fact that money not being transferred would prevent loading. Those two things are completely unrelated.
Yeah, and there's that point. And then I was even more interested in the other point, and that is whether the defined force majeure events actually covered this situation. Because I'm going back to the clause, but it talks about restrictions on money transfers, right? Is that the language in the clause? Yeah, restriction. Yeah, so that's the language in the FM clause in subclause 3, along with act of God and all the other ones, right? And that's when you deal with FM, you start usually there. What's the force majeure event that's happening? Does that fall within the list? Okay, now is it unforeseen? Can you do something about it? And all the other steps set out in the force majeure clause. But the event, it needs to be listed in that list, and it needs to be the cause of the delay, or the cause of, as you were saying, the prevention of the loading, not the consequence. And what do we have here? We have sanctions that may indirectly have the consequence of there being difficulties in the banking chain, as it turns out, as a matter of fact of finding. The arbitrator said, well, it shouldn't. This payment should have been able to go through. Practically, there may have been some complications with the banks being extra cautious and what have you. But really, the payment should have gone through from a legal perspective. They accepted, as a matter of fact, that the banks would have been cautious and there would have been problems, highly likely that there would have been problems, I think was the language they used. But in any event, take that as it is, that there would have been problems in this USD payment going through because of the cautious banks. That is a consequence. So these money restrictions, transfer restrictions, that is a consequence of a sanction-related issue. And sanctions is not a cause listed in the force majeure event. That is the cause, the sanctioning event. And I took, and it certainly wasn't something that the court went into any great detail here, but I felt that particularly Lord Justice Males felt quite concerned about that in a way, and that there may have been another argument to all this. But as he says, these issues are not the subject of the appeal, and didn't come to a finding on that, of course. But I wanted to make a point about that because, to me, that has greater significance for other force majeure clauses, for other cases. I always, want to try and impart some takeaways for those that are listening in on how to deal with subsequent force majeure issues or how to draft clauses. And thinking about cause and consequence in a force majeure event clause is a important task. Anyway, coming on to subclause D, overcome by reasonable endeavours. What did you make of all this?
Well, it's a tricky one. So in this situation, as I said at the start, the charterers said, well, we can still pay you, we just pay in euros and it gets converted to dollars when it hits your account. So you'll have the same dollar amount as you would. If there's bank fees, we pay the bank fees. If there's an exchange rate issue, we'll make you whole. You will end up with the same correct amount of US dollars in your account. And the reasonable endeavors of, for the ship owner in this case, was basically saying yes. That's it, really. They're not having to do anything other than just agree to the money being paid out in euros and then exchanged by their receiving bank in dollars. So it's not really a question well, it was. I mean, it was entirely a question of this, but it's not like a question of how reasonable a reasonable endeavor is, because they didn't have to do very much to just say yes, go ahead, you can do that. It's more a question of whether at all a party is able in that context to say, by way of reasonable endeavors, you're able to, or you're obliged under this reasonable endeavors provision to accept some form of performance which differs from strict contractual performance. And the interesting bit of this judgment is that that's almost the key distinction between Lord Justice Mayall's judgment and the dissenting judgment, is that in the dissenting judgment, they're very keen to say, no, this is a question of, are you entitled to require somebody to accept non-contractual performance? And Lord Justice Mayall looks at it slightly differently, and he says, no, what we're looking at here really is reasonable endeavours.
Exactly, and that's the key distinction in all this. It's where both of us, I think, had a little bit of trepidation, or it was more difficult to get to accept the final outcome here. It is because the contract provided for USD payments. The payment obligation was to make payments in US dollars, not in euros, not in Swiss francs, not in any other currency, but in USD. And what the charterers had offered was a euro payment to the owners, and that the owner's bank would then convert in very short order that euro payment into USD. And so practically speaking, what would owners get? Owners would get in their bank account some USD. That's what they would practically get, even though it was paid in through euros. Contractually, there was no mention of euros. They weren't entitled contractually to pay in euros. The question that we're dealing with, though, is not, and how the court approached it, is not so much what was a contractual entitlement or not. It was when you look at this from the perspective of a force majeure clause, and you look at it practically. So the owners want to rely on the force majeure clause. They want the benefit of what's written in that clause. They want to be able to say, as it turned out, there were commercial reasons why owners wanted to adopt this position, which is not surprising, of course. But they wanted to not have to continue to perform the contract. Presumably the market had moved against them. So with those kind of commercial considerations in the background, owners wanted to be able to say, the contract requires payment in USD. You can't step around that, charterers, and pay in euros and get around it that way. But the point here is that owners have to act, or constricted, if you like, by the force majeure provision, so that their ability to rely on the effect of the force majeure clause is conditional. It's conditional. It's this concept of conditionality, where it's conditional upon them having exercise reasonable endeavours. So in that way, you're looking at reasonable endeavours not from a contractual performance perspective. Is it contractually possible for charterers to pay in euros? You're looking at it from a practical perspective. Is it possible? Is it practical for owners to do this? Well, it wasn't going to cost them anything. It didn't take any more time. They had no real good reason other than their own commercial reasons to say, no, we don't want to accept this euro payment, which will be converted into USD on receipt. And that's really how the court looked at it, is you've got to look at this whole analysis in a force majeure context and how the clause is working. So essentially, had the force majeure clause expressly said through contractual performance or some connection with that the reasonable endeavours have to be performed within the context of the contract, then okay, that would have been okay. In the absence of that wording, the majority were of the view that it didn't necessarily have to be contractual performance, and it's a fine line. But when you think of yourself operating within a contractual mechanism and what that mechanism provides for, you start to see, well, okay, yeah, that makes some sense.
This is where you have the, all the questions start to come up, and I think there was a question raised by the dissenting Lord Justice, looking at these hypothetical situations where, okay, what then does constitute reasonable endeavours? If you have a force majeure event at a discharge port, and one party wants to rely on a force majeure exception to demurrage, for example, then is the other party entitled to discharge elsewhere? How far do you go in changing these? How far do your reasonable endeavours take you away from the contract that you've agreed? And this is why I think that Lord Justice Mayles was so careful to say there is no difference to owners, and actually, they don't need to take reasonable endeavours. They didn't need to go anywhere as far as reasonable endeavours. All they had to do was say yes. Go ahead and pay us that way. They didn't have to do anything really, because it didn't change anything about what they were going to receive from this contract. And that was the point he was very keen to make. And you wouldn't have to. This is the concern I have with the decision. When I say I think it's going to be relied upon a lot by people trying to do things that are significantly different from what this judgment is really talking about. I think there'll be a lot of people who say, well, your reasonable endeavours now in this FM context mean that you have to accept something which is materially different from what we've contracted for, and maybe there's some. Maybe that's helpful. Maybe there is a benefit to parties having a bit more of a difficulty relying on an FM event when they could, I don't know, they could accept discharge in the berth next door, and they say no, we're fixed to this berth. Maybe there's some good sense to that, but it does seem odd that the reasonable endeavours used to mitigate the effect of an FM event would require you to accept non-contractual performance.
I struggle with it as well, and I wouldn't be surprised to see this go higher, because once you start to think about different scenarios, as Lord Justice Arnold set out, I think it becomes difficult to accept. And maybe that is the answer, that ultimately this decision is confined to its facts, because it's one of those situations where, when you think about it, probably relatively narrow number of situations where someone can perform non-contractually, but do so in a way where you get exactly what you had bargained for. And I think that's your point, isn't it? Is that when you think about other scenarios, you're almost always going to find some burden on the other party. Here it would have been the owners in accepting that non-contractual performance. When you talk about payment, it's a very defined obligation, right? You have to pay a certain amount. You can be compensated for the additional finance costs and what have you. You get it. You can't really say, I haven't got what I needed here. If it is delivery somewhere else, then there's going to be some burden to that. There's going to be something that is beyond pure financial compensation in this way, or financial performance in this way. And that's where I think it does start to get restricted or narrowed on its facts. There's also the point about language, and that we've talked about this before, that if parties are setting out a contractual mechanism for something, which may codify the law, it may be something different to the law, off-hire clauses, safe berth warranties, force majeure events. If you're setting up some type of contractual mechanism that provides remedies, then you are working within the bounds of that contractual clause. And this could have been changed. There could have been reference to contractual performance in this, overcome by reasonable endeavours clause. Overcome, there could have been a different word used than overcome. There could have been different words than reasonable endeavours.
For me, that's quite an important point, right? There could have been other words other than reasonable endeavours, but even if it was much more narrow and much more prescriptive than reasonable endeavours, right? Let's say they've gone for an entirely new formulation of almost no endeavours, and you have the same case. It cannot be overcome by almost no endeavours from the party affected. I think it still goes the same way on Lord Justice Mail's analysis, because the actual act to overcome it from the affected party. So the ship owner is the affected party because they say we're affected because we cannot get paid. The act they have to do to get paid is simply communicate their assent to charterer's proposal. And once you're through the point of saying, well, it doesn't actually matter for this clause that the proposal was for non-contractual performance. Once you're through that stage, then you're into the question of how non-contractual does it have to be for it not to be reasonable endeavours? And reasonable endeavours actually does mean something. So the party affected have to do something. And if reasonable endeavours can take you outside of contractual performance, then you get into the analysis of how outside contractual performance is reasonable endeavours. And that's where I think it's a bit of a concern.
Well, yeah, stretch the example. What about if instead of paying in euros, they said, we've got this affiliated company who'll pay you. We'll pay you from some affiliated company that OFAC have no idea about. They'll pay you in USD. Okay, maybe there's a circumvention question. Okay, that's separate. But looking at this clause, is that okay? Should owners have accepted that?
Yeah, there is somewhere.
Or does that? But then I suppose you'd say, well, maybe that involves an additional sanctions risk. That's when you start to see, does it get confined on its facts? Because take that example and you say, well, that then involves running new credit checks on that other entity, or that then means that we need to do something or other to make sure we can receive this payment. We need to now check sanctions. There's some additional burden associated with that, which you can see on the Mail's analysis here. You'd be able to say, well, we don't. It's not reasonable endeavours to do that, or it can't be overcome by that.
But is it right to say that any additional burden means that you are outside of reasonable endeavours? Because to me, reasonable endeavours means that you have to. Yeah, there is a burden that you're willing to accept if you can use reasonable endeavours. It's not nothing. So when you've opened the door to it, then actually you have to, it's not a question of, are you asking us to do something different from the contract here? It's a question of, is the thing that you're asking us to do, which is different from the contract, an exercise of more or of less than reasonable endeavours? And that's a more complicated question, I think. In each case, it almost has to turn on its own facts.
Yeah. It's also a question of what's the it, isn't it?
Yeah.
The it here is an event or a state of affairs, and we didn't talk about this, but event is different to a state of affairs. Like an event is an actual act or thing, or that's something that's happened at a point in time, whereas a state of affairs is some circumstances, or it can be more than just one thing. And indeed, it cannot be overcome by reasonable endeavours from the party affected. It's not talking about some burden or a little burden, or that's not the test. So once you start getting into this, you can see where the argument is going to play out. Well, this is still reasonable. Why can't you accept payment from this other entity? Or we've got a debt from someone else. Why can't you take an assignment from them? Is that reasonable or not reasonable? You're still going to get paid. Someone else is going to pay you the money on the same time in the currency, not even in euros.
Maybe it's around overcome. Maybe that would be your argument there. You would say, well, you've not overcome the issue because somebody else is making a payment that you're supposed to be making. So the issue there is not overcome because the issue is that you're required to pay. But again, then you look at it through this lens and you say, well, we have overcome it because you were supposed to, provide us a ship and get paid a certain amount of money, and you were going to be able to provide a ship and get paid a certain amount of money.
We should pull up the quote. Where's the quote from that old 1960s case, which was referred to a couple of times? But basically, the parties have a bargain, right? They have agreed on the contractual rights and obligations between themselves. So to then say that, the other party should be stepping outside of that or accepting something that's not contractual is quite difficult. It's quite difficult to accept. It must be in Lord Justice Arnold's.
There's the quote in Bullman and Fenwick where the judge there said, "It's not a question between the plaintiffs and defendants as to what is reasonable or unreasonable. It is a question of contract between the parties."
Yeah, it's a question. Yeah, exactly. It's a question of contract between the parties, and I don't know. It's going to be one of these decisions that we're going to see this come up for sure. This is going to be debated in correspondence. I won't be surprised to see this go further up at all. I would use it for sure. I would use it. I can think of a number of cases in a sanctions context particularly where I'll be looking at this case to see how can I position on it.
I'm sure that a lot of our colleagues in the legal industry will be doing exactly the same. It's definitely one of those, though, when you drill into the specific, the ins and outs of the judgment, it raises all of these questions. And this is why I think ultimately it will be confined to its own facts in 10, 15, 20 years. But when you look at the situation as a whole, then justice has been done by this decision, I would say. The owner should never have been entitled to rely on the FM clause in the entirety of the taking all the facts together.
Yeah, well, I always I always worry about those cases where there could arguably be a stretch of legal principle to get the right outcome. And I think as I said at the outset that I didn't really hint at it, but the subclause C point around whether this was actually even a force majeure event falling within the clause, I think that was on the court's mind. I don't for a moment think that that's what guided them to their ultimate decision here. But, this does feel like the right answer from let's just say from an equitable kind of standpoint. But is it the right legal answer? And I couldn't help but want to read out this point. And it was a postscript, paragraph 64 from Lord Justice Mayles. As we have had occasion in this appeal to consider the Vancouver Strikes case, I cannot resist drawing attention to the concluding words of Lord Justice Donovan's judgment in this court. So it's the 1962 decision, 1QB 42 at 131. I should also like to record that the questions in this case, 1 of fact and 4 of the construction of the contract, have been resolved with the aid of only 55 authorities. 60 years on, I am tempted to say, if only things were still that simple. I read that out because what do you make, in the context of what we just said 2 seconds ago, how does that read in terms of Lord Justice Mayles, going through this exercise, getting to what is probably the right answer in a colloquial sense, but still kind of dancing through some of the authorities, if I can put it like that way, with the greatest respect. I don't know. I thought it was a really interesting postscript to put in.
I liked it first off just because it was fun. it was a fun thing for him to say. But also it does emphasize the point that the common law is malleable, and that, you know, it has I guess there is room in the common law for the right answer to be arrived at. And if I might be totally wrong, this might end up being a case where from now on it's just known that people have to do things outside of contracts if they've got a reasonable endeavours obligation to overcome force majeure. I suspect that's not right, and I suspect that it will be seen as a judgment which is very narrowly on the specific facts here, which were, again, to be completely fair, which were that it would have made absolutely no difference whatsoever to the ship owner had they just agreed to be paid in euros instead of for the outgoing payment by charterers to be in euros to arrive in their account in dollars. We would have made no difference at all. And I guess the reference here to the vast number of authorities that they have to go through to get to that point just emphasizes that, you know, if you look hard enough, there's an argument.
Yeah, I see that. I think you're right there, Calum. I really enjoyed it. This was a case I thoroughly enjoyed reading, thinking about how it applies. I don't know if I share the same view on it being confined to its facts. I think there's more leverage in this when you start to run it out. I think it has more effect. What I will say, though, as we've emphasised a few times through this discussion, and it's one of the key takeaways from this case, from any force majeure case, is look at the clause. What does the clause do? And there's a very easy way of ensuring that the type of outcome that there was here doesn't happen again, or doesn't get broadened, and doesn't have this effect that we're talking about it may or may not have. That's by writing into the contract what you want to do. What effect you want it to have. Now, okay, there's a lot of FM clauses that are already out there floating around, and it's sometimes not easy to change standard form FM clauses that are in terms and conditions that parties have been trading on together for a long time. I get it. I know that. And listeners may get sick of us saying, well, you know, improve your contracts and you avoid this kind of outcome. But still, when you're dealing with a contractual mechanism, it's not just force majeure clauses. As I said, it can be other contractual mechanisms. What you are providing for in your contract is really, really important. And I think that's ultimately what the court is saying here.
I agree with that. And I think, the contracts change over time. And I don't know if people would necessarily have thought of including this in a contract before a judgment like this. But if you want to make sure that there's a limit on the reasonable endeavours that you have to use to get around a force majeure event, then you can always just say, reasonable endeavours within the parties' obligations under this agreement, or some other formulation that gives effect to the fact that it has to be contractual performance.
Agreed. Totally agree. And when you put it like that, it's actually pretty simple solve. So thank you, Calum. Enjoy the discussion. Thank you, everyone, for listening in. We hope you've enjoyed it as much as we have. As you know by now, these podcasts are recorded on a first record basis. We just read the cases, jump on, talk about it, and see what comes out. It's not always pretty, but it's what we think and what we make of it. Hope you enjoy it. We aim to get these out every Thursday. And please do follow us. We're on YouTube, Spotify, Apple Podcasts, Google Podcasts. It makes a difference on the algorithm, and we hope that you're enjoying following along. So thank you. Until next time, take care.